Hello. Hi, everybody. It is Artie of Artie's Corporate Fiction. How you guys doing? Happy Tuesday. It's me and Serana saying hello. Hi, baby. What do you want, baby? I feel like you've gotten bigger since I've had you. It's been like 2 months now. Yeah. Okay. You want a hug? No. She didn't want a hug. Okay. How you guys doing? Hope you guys are doing well. We got 2 cases to take a look at. Pretty interesting. Hey, what's up, Beta Wolf? It has been a long time. Both involving the courts. Nibbler. One is pretty spicy. Another is also pretty spicy. We got I got a sovereign citizen, and we got a scumbag defendant. Apparently, I guess we'll find out how much of a scumbag he is. But it should be fun. Oh, hello, Maik. Hi, baby. Maik, what do you want? Serana. At least she's using the tree like a cat is supposed to, you know what I mean? Serana, come here. There we go. There's my baby. There's my baby. Okay. Oh, I gotta turn off some gamer elements here. There we go. This was featuring Judge McNally. So let's go.
I got started on Monday night. You got to fuck my sister. Oh my man. Stop. Fuck me. All right.
Are you ready on Brian?
Ready, Your Honor.
Habeas Trevante Bryant. 2 will be 716 3361.
Ready for the podium. Michael Carvin, 37384 on behalf of the defendant, Your Honor.
Your name?
Ready for the podium.
What, are you bringing your kid to court because you know you're gonna go to jail?
No, Your Honor.
Don't play games.
Oh, wow. Okay. Awesome. That's awesome. You know, you always love it when parents use their kids as shields.
Games with me.
I'm not playing.
Don't play games with me. I don't want people playing games with me.
I don't play any type of.
Listen, you better call somebody and have them come and get that child. You understand?
Yes, Your Honor.
Now, and then we'll call the case. What I'm gonna do, I'm not quite sure. But I've seen this little trick before. I mean, I didn't just get here 2 months ago, okay? We'll call somebody to get the child. I'll call a case when we're ready. And I'm telling you, if you leave, you're gonna have a big problem with me. You understand what I'm telling you?
Yes, Your Honor.
No, not yet, Judge.
People against Tyarius Trevante Bryant. 2-4-716-3361. Are you guys hearing this case, victims? Don't. Okay.
They're not.
All right, Mr. Carmen, your name?
Mike Blake Carmen, P73824 on behalf of them.
Mr. Bryant, come up to the podium, state your name. According to you, you're, I want to ask again. Let's just double check it, Mr. Kimberly Dennis, Durrell Lee, Margarita Bruno Hayward, Joseph Matthews. Are any of those individuals, bring Mr. Mohammed?
Yes.
Any of those individuals in here today? All right, it does not appear as though they're on Zoom. They did not step forward on the case when called. Mr. Carmen, why don't you and your client approach the podium, please, and then tell me whether or not there's any material additions, corrections, or deletions.
Your Honor, as far as his employment status, he, since January of 2024, has been working at Cosmic Comics, both in Livonia and Fraser. Both locations earned $340 a week. They'll lose that job if he has to go to jail. He has been living in Romulus with his girlfriend. They've been together since 2019. They have 2 children together, ages 1 and 7 months. He just made arrangements for her to pick up the 7-month-old. Your Honor, he's not been incarcerated in several years. He does have a pending matter in Wayne County that's set for sentencing next Monday.
Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of the people.
You wrote down full restitution on this. I just want you to be aware, this is the B&E vehicle to steal property, 200 or more. I just want you to be aware that none of the victims are here. Or less than 200, I'm sorry. He pled the count.
I was trying to hear what he was in for. It sounds like he theft of property, I guess, involving a vehicle. So I assume like maybe he broke into some cars and took stuff. That's what it sounded like. But the judge is saying that none of the alleged victims are present.
Count 2 was dismissed, but Lisa, just confirm that my understanding is correct. It looks like he pled guilty to count 1, which is the 1 year, and count 2 was dismissed. Is that true?
That's correct.
So I just want you to be aware of that.
Yeah, and Judge, I apologize. Which case is this?
This is Triarius Travante 1. It's a B&E vehicle to steal property, 200 or more, but less than 1,000.
Yeah.
It's a 1 year. Well,
Vehicle
I just want
break-in.
you to be aware I called the names. You're not here. You just put down PSI full restitution. And none of them show, so I'm not gonna order any restitution out of this.
And Judge, may I ask, does the court send notices to them or?
Yeah, we did send those.
Okay.
The probation department did when I ordered the pre-sentence report.
So, I
Okay,
understand, Judge. Thank you.
all right. Anything else, Mr. Carmen?
Yeah, since my client shares, the care and custody
Oh my God, what is going on with the audio in this
of
courtroom?
young children with his girlfriend that he lives with. If he's got to go to jail, it's going to be very hard on our young family.
You should think about these things before we go out and steal. I mean, seriously,
I understand, Your Honor.
I don't know if you do or not. I find it a little hard to believe. I mean, you could sit and give me lip service, but you had a RNC motor vehicle. In 2021, you had a domestic, where you didn't comply with probation in 22. Conviction was entered on that. You had a retail fraud. 23, we're just convicted of felony retail theft. In Illinois, we have another case you're bound over to the 33rd, I'm sorry, bound over from here, stealing or retaining without consent a financial transaction device. That's the case he's going to be sentenced on?
Yes, Your Honor, and there's a sentencing agreement
I assume that means like stolen credit cards.
in that case of 2 years probation.
I mean, that's great.
just informing the court.
No, I get it. I'm just telling you, he's got bench warrants out of the 34th for assault and battery.
Oh.
Bench warrant out of the 52nd.
Oh, wow. He's got bench warrants all over the place, too. This guy.
For retail fraud 3. A bench warrant for retail fraud 3 out of Southgate. Retail fraud bench warrant out of the 16th.
Retail theft, assault and battery, retail theft. Got sticky fingers.
You all got any of those?
Yes, Your Honor.
When?
I've been taking care of the warrants since I've been out, Your Honor, and
Lisa, can you run his lien again for me, please? This lien
Sure.
is a few days old. Let me just double check.
And my client indicated he's contacted those courts.
You contact.
yes, Your
What
Honor.
do you mean?
I contacted those courts and they told me that I have to turn myself in and schedule.
Well, you haven't taken care of the warrants then, have you?
No, I have been taking care of some of the warrants, Your Honor.
I'm sorry?
I have been taking care of a
All
number.
right, I'm gonna just check with her and see. Now you're breaking into cars. I mean, I don't know what to tell you. You've been unemployed and then you were working at Fast Splash Car Wash. You collected money on a bridge card. You need to go back and get a GED or a diploma. You need to work harder. I don't know why you're not working. You need to work. That's your decision though. But to go out and support a family by feeding all the time is not the answer.
Your Honor, he is working, and I updated the
Little
court
bit.
on
I know you did, but still, this report was just done, right? This report was just, let me just double check this. I ordered the pre-sentence report on March 25th. I'm just telling you that they reported then that he was unemployed for the past 8 months. Why were you unemployed for the 8 months preceding that report?
I wasn't unemployed, Your Honor. I was just helping my baby mother going through the postpartum and dealing with the kids. I was still working,
Well, you told them you were unemployed. Reports being unemployed for the past 8 months.
and I don't know why I put that, and I shouldn't have put that. I've been working
Yeah.
since January 2024.
All right. Lisa, you don't see any of those other warrants. I think you just answered my question. You don't see any of the other warrants cleared out of the locations I just mentioned, right?
I'm just running it right now. Give me 1 second.
Yeah, take your time.
No, I don't see any other warrants.
You don't see what?
I don't see any other warrants.
Well, I'm just saying, see the lien in here, but probation reported open warrants issued the 37th District Court, 16th, the 28th, the 34th, and the 52-3 District Court. Do you see any of those warrants on his lien now?
No, I just ran it and I do not see any warrants.
Good. All right, well, anything else?
Anything
Your
else?
He did not spend any time in jail on this, correct?
No,
Where's the child now?
She's going, Your Honor.
I'm sorry,
She's going, Your Honor.
was the mother of the child here?
No, she wasn't here. Someone else came and picked her up.
Okay.
It's supposed to mean like you become a professional thief.
Hmm.
200 fines, 400 costs, 75 victims' rights, $50 justice assessment, 7 1/4, and 40 days jail. You'll serve 325 more if you don't pay your fines and costs. I'll let you pay those at the rate of.
So I just heard that 40 days in jail. With another 364 days if he doesn't pay restitution. So here we go.
7 1/4 and 40 days professional thief. 200 fines, 400 costs, 75 victims' rights, $50 justice assessment, 7 1/4, and 40 days jail. You'll serve 325 more if you don't pay You're fine.
I'm sorry, 325 more, not 364.
Costs, I'll let you pay those at the rate of $75 per month. And I will let that start beginning on June the 15th. If you don't have the money at any point, you call the court. I'll be happy to give you an extension. You have 21 days to appeal, 14 days to apply for the court. Good luck to you. I wish you well. Thank you. It's Mr. Strong out there.
No, not.
As part of this, we have heard a ruckus from the jail
All
holding.
the grave of judge already went down.
Who's that behind my monitor? Serana. Hold on. Serana? What are you doing behind my monitor? Are you being a bad girl? Serana. Come here. Come here. You're staring at me. Get over here. Come here. Come here. Serana. Come here, baby. You're sitting on my router. No. Serana, come here. Okay. My baby.
UOB 716-3361. Mr. Brian, you need.
I hear you, Brian.
Listen. I'm not gonna put up with you yelling and screaming back there anymore. If I have to call you out here again, I'm gonna give you 30 days for contempt on top of the time that I just gave. 30. You don't get to act like that. I hope you clearly and fully understand me. If you don't, I'm gonna have you out. Because I would hear you again. And then I'm gonna lock you up for 30 days. And we're gonna do this all day long. You're not gonna make a scene here in the courtroom. That sentencing, if anything, was too light. I'm not playing with you,
How is it too late?
Mr.
I have a judge that I gotta go to felony court. This is district court. I got sentencing on felony court.
Knock it off. Knock it off. And
Uh-oh.
go tell them. You have 5 or 6 felony, you have 5 or 6 theft offenses, you're breaking into people's cars. Just think you could make a living by being a thief?
But I'm
Yeah.
not a thief.
Oh, okay. Have a seat in the back, speak up again, you're getting 30 more days, I promise you, that's not a threat, it's a promise.
Bro, I don't give a fuck.
Good, come here, contempt of court, bring him up.
Well,
No, bro.
he's
You're
done.
gonna send another.
Oh, he's fighting.
You're gonna get. I got people saying, you know, I don't care. You know, I ain't ready not to move. Get up. Excuse me. People stop for counting. Be run over. Run over flat. Run this shit over. At all. At all. So I got surgery on Monday, darling. You got to fuck with my sister. Oh my man. Stop. Who wait? Fuck with me.
All right. Settle down.
You off, man.
Go down.
No, you're gonna get taken, bro. Tase me, dude.
Tase me.
You know what? We don't.
Stop resisting. Like I got kids that I never ran by myself. Making it die. You keep making it seem like I'm just a thief. I got proof. I don't see what you're doing. I got proof. I make it worse.
Knock it off.
Hey, listen to me.
Brian,
Look at this. You're making it twice as bad.
Mr. Brian, go back in the back. I'm gonna let bygones be bygones, except for the initial jail term. One more word, and I'm telling you, you're doing 30 more days.
How many days?
Enough. Enough. Just control yourself.
Okay.
Stop stealing.
Yeah, it is not already. Yeah, bro. Go inside, to the other side. It's real good problems out here, real life, bro. And y'all just be locking the fuck up for no reason. Alright. I never understood that, bro. For the women, Oh, let me come in the king, bro. Don't let her go. She be good. Oh, let me be good, bro.
I have no idea what he's saying there.
Good, bro.
Jeez.
Talk to you later.
I understand.
I mean, yeah, he can't control himself. I mean, but damn, dude, like, he's got multiple warrants out in multiple districts. There's a pattern behavior because a lot of it involves theft. If he can't control himself, I mean, I don't know, what do you want me to do? I mean, I look I mean, think about the people whose cars he broke into. I mean, they got to deal with all that shit. Adam asked, what are my thoughts about the stabbing? I know nothing about it. I genuinely don't know much of any of the details on it. It's pretty spicy. I'm probably going to keep my head out of that one. So I'm not gonna. I don't have any opinion to give on that.
I have one ready.
Bring it up, Judge.
Who did he do that to you, right?
No, I know that did that, you're right.
I didn't hit him, Judge. I didn't hit the cops.
I
Jody, stand up here, Judge.
I'll make that up too.
Standing in for our old friend.
People again.
Okay. Let's go to the next one.
Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of.
We are on the record in the 13th Judicial District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr.
Oh, that's right. We have a
Estrada,
Blandino
you
appearance
were
today. We might take a look at that too.
convicted of displaying an illegal Kansas or an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
This, Your Honor, this was
There
the
it is.
exhibit.
Oh, wow. Wait, so not only is it a fake plate, but he also had the gall to put in like a disability logo on there.
there it is. Thank you. And that was manufactured at your request by
Basically meaning that not only is he getting out of trying to drive, getting out of paying for license and registration and all that jazz, but he also wants to be able to park in handicapped spaces.
a private vendor, and you were found guilty, and you said you were going to appeal.
He might actually be
I
disabled.
don't
Well,
believe you have paid. I don't believe you've posted your appeal bond. And then you filed some motions for today, but the main concern is you need to either pay or appeal perfect the appeal. And if you don't, I'm gonna have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So
Uh-oh.
let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that. Notice of appeal, so you started the appeal process. But typically, they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the properest, and I got a letter from the appellate court, and they said that I needed to be signed. I sent it in, but it needed to be signed, so I submitted. As soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason, it didn't go. But if I get the signature, then I'm continuing. I'm doing it. Everything is supposed to.
Well, I see you filed one page. It says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well, apparently, Mr. Dean, that's up to the district court to make that determination on an appeal. I would have thought the appellate court would have made that.
That would be my understanding as well. I don't know what letter Mr. Estrada is speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing.
Nothing.
Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it. Etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may.
Well, I show the journal entry of trial. Let me see if it was filed February 21st, and that shows that he was found guilty of displaying unlawful tag.
I think he's still within his
starting to remember this guy
time period. So
I think so too. So, Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
no, we can't. Why don't you read it to us, Mr. Estrada?
Oh, well, can you read it for me? I have my wife because I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2/25 the certified envelope postmark.
Hey, ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really tell you.
I can't track it. If you get in front of the camera and tell us your name.
Hi, my name is Annie Estrada.
Anna Estrada?
Oh, is it the wife?
Annie, A-N-N-I-E?
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front of you with the...
Oh, God, yeah. Jessa.
Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the,
Just the
That
pertinent part.
part, okay.
Body of the letter, where
Okay.
it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in forma pauperis, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance.
Nothing.
all right, so you.
Yeah, exactly.
You've not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the
Yeah.
Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Which I already did.
Clearly you haven't, sir, because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you filed with the Court of Appeals.
True.
Specifically,
Don't interrupt me when you finish.
they specifically advised you that you had not.
Oh no.
And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, it does. I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform and under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because
it's a bunch of bullshit.
Share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby denied. And let's see, journal entry of continuance. Did you file that?
I think the journal entry of continuance, Your Honor, may be the last one where we were reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
And the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May. It hasn't been properly completed at that point in time. The state would be moving to dismiss the appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything. So I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigents, which you already have, and then the request for the records. I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, "Do I need to send one directly myself, or do you get a copy?" I'm talking Mr. Dean. The judge and Mr. Dean gets a copy, and they say, "No, don't worry, they get a copy." So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
Yeah, who?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record.
Who is the court of record? Is that the district court? Is that the court of appeals? Did you send it to the clerk? You sent it to the judge?
I sent it to you directly, magistrate, and I sent it. I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also. That's why I submitted this already.
Okay, order to remove the document should not be filed. I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time, and it was premature. You shouldn't have filed that, so that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the.
Does informal papyrus cover the cost of any appeals bond the judge put in place, or only the filing fees? That's a good question. I'm not sure. Usually it's for the filing fees. I think even in a informa papyrus motion, you may still be subject to the cost of like transcripts, but I'm not 100% sure of that. Yeah, I'm not. Don't quote me on that though.
File. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can see there was a paper. Let me see. Let me go see what it was.
See if it's clerk's office. But as far as the informa papyrus, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney, since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney. And you fired that attorney, and then we appointed another one, and you didn't want to use him. But as I recall, you
What a waste of time this guy is.
you do have a monthly income. And remind me, does your wife work?
No.
Okay, well, I have never seen I've never made that determination. And I'm not inclined to make it at this time. You do get some income, as I recall. And if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the.
Okay, so then yeah, so informal papyrus would also cover the transcript, or maybe not. I don't know.
Filing fee.
I'm requesting the papyrus because it'll cover it, and then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request, and all I need is the letter that I submitted, which is for some reason they're asking for you to sign, so I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to, the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that Dylan, we've received his copy of the of this motion to dismiss liability. I'll give you one piece of advice when you're filing something. What the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the district.
You gotta CC people. Gotta CC the parties.
Magistrate Judge Webster and their addresses and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address, but in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
All right, Missy, what do we have in May? All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear to May 11 at 9 a.m. You're either going to have that paid and cover all of those matters that the appellate court has listed, including paying that appeal bond, also known as a supersedious bond, that needs to be paid of $158 cash. So,
May I ask a question?
go ahead.
Yeah, I just need to know if you're going to sign the formal papyrus letter that I sent you.
Probably
I'm
not.
not signing that at this time.
Huh.
That would be holding justice from me.
Well, so you believe, you also believe my decision was holding justice from you. That's my order at this time. I'm not going to sign it, and I'll take your pay or appear up at the date and time given.
Or there's a particular procedure that you need to research on how you go about making that request to the courts. You don't just send a document saying, "Fine, make this finding," without a support. That's not the way court works. Your Honor, I'd ask the court to go ahead and approve this journal entry since these documents will be needed, probably potentially supplemented to an appellate record. Mr. Estrada, if you agree that this is what we did today, then you can say yes, and I'll put an S/ showing that you've approved it. If not, Your Honor, if he's objecting, instead of going through the whole lengthy Rule 170, I just ask the court to approve it if it agrees. This is the case caption, case number, the date that we all appeared, that you appeared, or that Judge Webster was hearing this matter, that you, Mr. Estrada, appeared via Zoom, that this case was set over to May 9th at 9 a.m. And it's, set over as a continuance. It's not granted, or time's not. completion of the docketing statement. It's on that box and there's no need for it.
Most attorneys have shit handwriting.
And there's nothing else contained.
I have terrible
sorry.
I
handwriting.
guess I should have put that the motion to dismiss liability was denied.
Yeah, but that is denied.
That must have been what I was planning on, and then we got to discussing some other issues.
And you might put in there that the defendant needs to either pay or post his appeal bond and perfect his appeal, something to that effect, by that next court date.
And that was 11 o'clock on 5/9, right?
Yes, I was gonna ask about that. The
Oh,
But-
I had it. Okay.
Missy said 11.
All right, I'll get that changed to 11.
I wonder, Missy
Yes.
no, just leave it there.
All right, if we can do it at 11 if you want.
No, that's fine. Whatever you have.
So it's a 9 o'clock or 11 o'clock?
Whatever Missy says, that's what we're gonna go with.
I've now changed it to 11. I thought that's what everybody wanted.
Okay.
So change that to 11 a.m. And then Your Honor went ahead and added what we just discussed, that the motion to dismiss liability is denied, and further that he needs to complete the docketing of his appeal. Complete the docketing of his appeal, pay the appeal bond, or pay the case in full by the next court date. Mr. Estrada, do you agree that that's what the court just ordered?
I hear what you're saying.
Your Honor, to ask the court to approve.
Approved. I understand you don't agree with the orders, Mr. Estrada, but they are what I ordered.
I'm simply on the defendant's signature line going to mark approved over defendant's non-response.
Huh. Okay. Honest to God, I don't know what to do with guys like these. It's kind of tough. Because you don't want to just dismiss the matter and be done with it, because it's just going to encourage him to continue on with this behavior. But it's also like he is sucking up so much court resources over a $50 ticket. All right. Let's hear about Mr. Blandino.
The state had any response?
I'd like to note though for the record that they filed no response whatsoever in writing. Therefore, anything Mr. Dickerson has to say can't really be serious. If it was serious, he would have put it in the paper. Everything that
Oh God, I forgot he's so like a Trump thing on his jacket.
I'd like to note though for the record that they filed no response whatsoever in writing. Therefore, anything Mr. Dickerson has to say can't really be serious. If it was serious, he would have put it in the paper. Everything that I say.
Thank you very much. Go ahead.
Thank you. Our position would be this, is that the defendant has shown no basis for two things. Number one, to regain his right to self-representation, which seems like he's trying to end run here without explicitly saying so. Seems like that's what he's trying to get at. Number two, for taking Mr. Gerstein off the case, Mr. Gerstein has done a fantastic job for the defendant. He has fought tooth and nail at every corner. And there seems to be no basis for his motion, and to expend unnecessary resources by appointing somebody new, and especially with such a difficult defendant, to appoint somebody new to have to take on this defendant, and who knows where that goes. There's also really no reason that any new litigation needs to be occurring. I do think that there's possibly some litigation going on with Metro right now, but I don't know if that's even in this case. I think that's in the Justice Court case. So
being a bad kitty.
For three reasons: the self-representation has been revoked. There's no reason to renew that and give him another chance at it. Number two, there's no reason to take Mr. Gerstein off the case. And number three, there's no basis for there to be anything going on in the case since the case is closed.
Well, it's a new proceeding. He filed a post-conviction.
What's
So it's a new proceeding. So, anything else?
Yeah, I'd like to reply to that. This man here is slightly delusional because this is a writ of
Ooh.
habeas corpus. It is also known as the Great Writ, comes down from the Magna Carta to challenge
me.
the legality of the custody.
Hey, we're just on the
Uh-huh.
appointment of counsel issue.
Exactly. I filed this representing myself, which I have the right to do. Under WITIS and under the case law on this, which I outlined clearly in there, I don't know if Mr. Dickerson even read this motion.
No, I didn't, because I was not served with that, Your Honor.
He was served with it. If he's gonna deny service, I'd like him to do that under penalty of perjury.
My goodness.
So the case is clear on habeas representation is and we went through this the last time. A, is the issues presented are difficult, and B, counsel is necessary to proceed with discovery. This being a new case, the revocation of my right to represent myself in the main trial has no bearing whatsoever on this. That's not a perpetual thing that goes there every time I come into every courtroom. Although Mr. Dickerson in Justice Court made it clear to present
Nice,
what
all
happened
right.
in this court.
Thank you.
And
Appreciate
Judge
it.
Sacento denied me the right to represent myself in the Justice Court, which should be a disciplinary thing with the bar. But the issues are difficult under Brown versus Eighth Judicial District Court. Counsel is necessary to proceed with discovery. I'm gonna have a lot of discovery because the witness is called. You judge, do you know that Paul Dyla came and testified against me? He was not called as a witness on direct. He could easily have done so, and they're gonna have to subpoena Ducis Tecum, all the evidence that they have at the Commission on Judicial Discipline for this. That's a massive undertaking, plus the letters of caution that were issued based on my complaint. He's gonna have to
Okay,
testify.
all right, so
Okay.
at this time, I think I've heard enough. The court will issue a minute order. Thank you very much.
So
You're not gonna say what your
I'm gonna
determination is?
issue a minute order.
Okay.
Thank you very much.
Okay.
can I just make a quick record that anything that he's serving regarding a petition for writ of habeas corpus needs to be served on the DA's office. It's gonna be handled by our appellate section.
I don't know where he served it.
Yeah, I
but
don't know either. I haven't seen.
Where'd you serve it? Did you serve it on, I'm assuming you did, because you're telling me you did.
Now the petition is not required to be served. I was presuming he's talking about the motion, but
For the motion.
I did serve him by email on the this motion for leave for standby counsel.
All right, thank you
And if I
very
didn't,
much.
I will let the court know if there's a clerical error on my part, then I'll admit to it and fess up. But to my knowledge here, I did serve him. But the other thing,
I
Judge,
appreciate
as
it.
you know, I'd like to have the transcripts as usual.
Absolutely, no
And
problem.
can you order that I get the jazz as well at no cost? Yeah, thank you.
That's right.
Thank you,
you
Judge.
very
Have
much. Have a good
day.
one.
Your Honor.
Is service by email allowed? It may the jurisdictions may differ, but usually no. No, email service usually isn't allowed. Okay. All right, I think we're done here, people. Today was a long day. It's gonna be longer still. A little bit tomorrow. I'm probably going to change out of my work clothes and take out the trash and put on some Doom or something. I don't know. So Thale's right. Usually email is like a thing of last resort. Yeah. Oh, really? Yeah, I get it. It depends on the jurisdiction. But it's usually like, it's because there's so much that can go wrong with that. Yeah, I would imagine it's like a method of last resort in most jurisdictions. All right, you guys have a good one. Check out my Discord. Check out hit that like button on your way out. Much appreciated, and I'll see you guys next time. Take care. Bye bye. See you tomorrow, I think. Maybe. We'll see. All right.